We are speaking now with Attorney at Law Peter Champagnie, Queen's Counsel. Want to hear from you, Mr. Champagnie, an idea or to help us to clear up these issues in respect of the penalties that now exist for breaches of the Immigration Act. What is on the books?
Well, in respect of the Immigration Act, I think that the relevant section for the purposes of this discussion would be section 9.4 and 9.5, and essentially speaks to a breach where someone fails to give the proper information upon arrival into the island, and the fine is, I believe, normally about $100. In respect of the Quarantine Act, I believe it's section 10, and that speaks to a situation where the fine can be up to $500,000 or 6 months imprisonment or both. Now, what is interesting is that in relation to both legislation, I do not believe that they would attract what is known as a recordable conviction, meaning to say if one were to go to court on either of these pieces of legislation and is found guilty or pleads guilty, I do not believe that the person would attract a conviction that is recorded, that would go against their name and have serious implications thereafter. So it is my respectful view that having regard to the situation as it is now in terms of this pandemic, Parliament may wish to revisit certainly the Quarantine Act and to put more teeth in it to make it one where the penalties are more severe, not necessarily in terms of fine, but in terms of it being a recordable conviction, and for the Quarantine Act to extend beyond speaking to just ships or aircrafts, but dealing with local cases of persons that are infected and persons being ordered or the suggestion being made that they be placed in quarantine.
One of the emerging concerns here is, in fact, the Prime Minister has been on the record as saying that he will instruct the Attorney General to urgently review the fines that relate to the breaches of these acts.
Yes.
In the event that a breach would have been committed before the fines are reviewed, will the old penalty exist or will the new penalty be applicable?
Well, the general principle in law is that legislation cannot go backwards if it is not specifically stated. So to answer your question, it would be as at the time that the offense was committed and not a situation where fines are done retroactively. So that would be the issue or the answer in relation to the question that you have asked. I do believe that the Prime Minister is spot on in terms of the review of the legislation. It is certainly in need of review. And, one can't really fault the legislators too much because I don't believe that anyone would have predicted this kind of situation arising, certainly it being something that is new.
Except, though, Peter Champagnie, that the Justice Minister had been on the record as saying there were several laws in respect, and that would apply to several ministries, in this case, the Ministry of National Security, that were in need of review. And this was coming from the Tesha Miller incident where he was fined, I think it was $100. So is it that the government has moved too slowly on fixing these issues?
The answer to that is yes and no. Yes, in the sense that the fines, certainly in respect of these minuscule amounts, $100 and so on, is unacceptable. But it is going to require intensive review because it's not just confined to the legislation in question, but many other legislation. And that has to be done over time because there are a lot of legislation on the books. The answer can also be responded to in a way in the negative because the fine, certainly under the Quarantine Act, although it was an act that was passed, I believe, in 1951, it makes reference to fines of $500,000, fines of $1 million. So it is actually quite impressive in that regard.